the Solonus lawsuit against SAP, legal pitfalls in digital transformations, and why ERP software vendors are the new mafia. Those are just a few of the topics we'll cover here in episode 214 of Transformation Ground Control.
Welcome to Transformation Ground Control. Ground Control. The podcast that covers everything related to digital transformation. This podcast features technology agnostic and international discussions related to digital strategy, software selection, implementation, change management, business process optimization, and everything else you need to know to make your digital transformation project successful. Whether you're embarking on an ERP implementation, supply chain transformation, or any other business or digital transformation, this podcast is for you. Now, here's your host, Eric Kimberling.
5, 4, 3, 2, 1.
Ground control to Major.
Hello, welcome to Transformation Ground Control, episode number 214. My name is Eric Kimberling, the host here today. I'm the CEO of Third Stage Consulting. We're an independent consulting firm that helps clients throughout the world with their digital transformation journeys. And joining me, as always, is my co-host, Darian Chwialkowski. Darian, thanks for being here today.
Yeah, thanks for having me.
Excited for today's show. We've got a great episode planned for you today. A great guest coming up here later in the show. We're going to get into some newsworthy topics here to get started. We're going to actually start off with some social media questions we received. Then we'll get into newsworthy topics. We're going to talk about Microsoft Power BI's recent price hike. And we're also going to talk about this Celonis lawsuit against SAP alleging anti-competitive behavior. So we're going to talk about that and what that means potentially to your digital transformation or your SAP implementation if you're involved with one. And then later in the show, we're going to have Marcus Harris on the show, who's an attorney who's going to be here to join us to chat about legal pitfalls in digital transformation. We're going to talk a lot about not only just sort of basic contractual issues that you might have with your digital transformation, but more specifically, we'll get into AI and some of the data privacy, data ownership, intellectual property, training AI models. What does that all mean for your data and your ownership of intellectual property? All that stuff we're going to get into with Marcus Harris here later in the show. And then after Marcus is on the show, we will discuss why I think software vendors are the new mafia. And we'll talk about what that means and why that is and what you can do to hedge your risks against that potential risk here in just a few minutes. But we'll cover that later in the show. But before we get to all that good stuff, what social media questions do we have this week, Darian?
Yeah, this first one's interesting. Isn't the future state and organization of the GL to support the business structure one of the first things that should be determined in the build stage? Shouldn't this actually be addressed earlier during selection, scoping, or discovery phase, or were there organizational changes that led to shifting targets?
Yeah, so I think the question or what that person's alluding to is just at what point do you define the GL and sort of the accounting structure, which is really a foundational piece of any sort of ERP implementation. And the person brings up a good point that you can and should be doing that stuff early on in the implementation, even before you start physically actually deploying technology. You should be defining what you want that GL structure to look like, what you want the accounting organization to support that GL structure, what you want that to look like. And, a lot of times, this is one of those activities that will oftentimes cause delays in a project because what happens a lot of times is a company decides they want to move forward with a certain technology. Let's say it's, an ERP vendor or ERP provider that includes the financial GL piece of it. What happens is a lot of times the accounting department will inadvertently slow down the project or delay the project because they're trying to figure out what that new GL structure is going to look like. They use this ERP deployment oftentimes as a way to consolidate results better and to have a more unified chart of accounts and GL structure behind it. And if those decisions haven't been made before you start the implementation, then what happens is all the consultants show up and you've got this army of people there ready to roll and they're charging you by the hour. In the meantime, you're trying to figure out what we want our GL structure to look like, and they're still billing you by the hour while you're trying to figure that out. So that's how you end up delaying a project, budgets start to get overrun and that sort of thing. So the more work you can do up front before you get the army of consultants involved and before the meter starts running on the actual transformation, the much better off you are. And that's something that we'll oftentimes do during our phase zero engagements, when we're working with clients before they actually start the implementation, but after they've already chosen what their roadmap and technology is going to be, we'll help them define their GL structure, among other things, as part of that phase 0, so that when the actual phase 1 of the project starts and you have all the expensive technical resources billing by the hour, you've already made those decisions and you already have that clarity of direction that you want to move forward with. So that's, generally speaking, that's how you would address that GL piece of it in a digital or a general financial transformation.
Yeah, absolutely. That makes sense. Our next question today is, or I guess I want to get your take on this comment, is private cloud seems to be a nice compromise to carry forward legacy capabilities and to leverage new innovation. And not sure the partners for small to mid-tier make things better or worse when compared to direct SAP support. What is your take on that?
Oh, well, unfortunately, I don't think either party does a particularly great job or a particularly stellar bang-up job of implementing technology in general. I hate to say, but I don't know that any one party is better or worse. I mean, some people would say, well, if I'm deploying SAP, why not just hire SAP direct, because they're the ones that really know the software, they created the software, et cetera, et cetera. I mean, the reality is those professional services groups are separate entities within the broader SAP organization, and they were not the same people that created the software. So it in some ways, it doesn't really matter that they happen to come from SAP. Not to mention the fact that most of these big system integrators, especially the big consulting firms, they're hiring from the same pool of subcontractors as every other system integrator out there, including SAP. So having said that, I mean, I don't think there's a material advantage to working with SAP direct. I also don't know that you necessarily get a material advantage by not working with SAP or choosing a system integrator, other than the fact that system integrators are more likely to have a bit deeper, more focused competency that might fit you better. So if you're in a certain industry like manufacturing or government, public sector, whatever it is, you're more likely to find a system integrator that has that relevant experience within that vertical, compared to SAP, which is more of a broader, one size fits all, cross industry experience base. So that'd be the one caveat I'd say that could be an advantage to the third party implementers. But generally speaking, I mean, there's good ones and there's bad ones out there on both sides. You just have to find the one that is best cultural fit and kind of meets the criteria you're looking for.
Yeah, absolutely. Well, I want to kind of switch gears here and get into our first newsworthy article of the day. The big story, or the first story of the day, is that Solonus has filed a lawsuit against SAP, accusing the ERP giant of abusing its market power to stifle competition in the process mining space. This lawsuit, which was filed in San Francisco, claims that SAP is making it virtually impossible for customers to use third-party process mining solutions. And this is how they do it. They charge excessive fees for accessing SAP data through non-SAP tools. They push their own process mining solution. You might have to correct me here, but I believe it's Synavio. Yes, Synavio. At significantly lower cost or even for free. And they also spread misleading information about the risks of using non-SAP solutions like Celonis itself. So Solonus argues that these tactics are designed to force customers to stay locked into SAP's ecosystem, making it difficult and very expensive to switch competitors. SAP, for its part, has declined to make any comments so far, so we don't really know what their side of the story is. But I guess I have some questions for you about this, Eric. If these allegations are true, how much does this limit competition in the process mining space? And is this just business as usual for large software vendors, or is this SAP really crossing the line at this point?
I've always thought that there's an issue with, ever since SAP bought Signavio, I've always thought, and we've actually noticed it materially in the marketplace, where they are pushing that product so hard that they are, we've seen them sort of push out other third-party options like Solonus. I mean, we work with Solonus. We're not affiliated with Solonus, but we have worked with that tool before. We've also worked with a product called Mavum. It's a company we partner with that provides not only process mining, but process mapping and process management software. It's very robust and in some ways better than Signavio. But SAP creates this closed off ecosystem that really hinders, I think, third-party options. And I think that's their MO. I mean, that's how they built such a juggernaut in the industry. I'm not saying it's okay. I absolutely do not think it's okay, but that is how they built their juggernaut marketing and sales engine that is SAP's marketing and sales engine as we know it today. So that's the way they do it. They create the system integrators, the third party providers. They through acquisition, they go out and buy companies like Signavio. They go buy Ariba, SuccessFactors. They buy all these products to kind of create this closed off SAP ecosystem. And if you're not part of it, you're not welcome in it. So it's sort of the opposite approach that Microsoft takes, or vendors like Microsoft, where Microsoft is sort of the opposite. They take it to the other extreme and say, we're going to open it up to development to third parties. And, they want to play nice with other third party systems. That's sort of their, niche in the marketplace, is being more flexible and more open. SAP has never been known to be an open ecosystem. Either you're part of the ecosystem or you're not. And if you're not welcome in it. So, and that it's, frustrating for us as independent third-party advisors too, because, our job is to not care necessarily about SAP. Our job is just to care about clients. And, SAP doesn't like that. And SAP's partners don't like the fact that we're not drinking the SAP Kool-Aid. We're not worshiping the SAP gods. We're just there to help our clients with whatever the needs are. So I think it's an interesting lawsuit. I'll be curious to see how it pans out. I know we'll have Marcus Harris on the show later today. We probably won't get a chance to ask him that question, but that'd be an interesting thing to talk to him about at some point, as far as what that, potential anti-competitive behavior means. Now, I don't know. I'm not an attorney, so I don't know if the lawsuit meets, and even everything I just said, my concerns with the industry and in the SAP space. I don't know if that is enough to say that that's anti-competitive behavior that is worthy of a lawsuit or a valid lawsuit, but just from a more of an ethical freedom of choice perspective, I think that what SAP does and their strategy, it turns off a lot of customers, and a lot of our customers do not like the approach that SAP takes. And I think this is just one more step in that direction. That, if you're fully all in and on SAP, then maybe it's a good thing. But if you're the type of customer that, you want to use SAP, but you also want to use other products and have the freedom to kind of pick and choose what kind of technologies you use, where you want to use them, it's not such a good thing in that case.
Yeah, absolutely. And if, let's say that you're a company that's currently evaluating ERP systems, what should you really watch out for to avoid getting backed into this, like locked in vendor controlled ecosystem? And what strategies can businesses use to maintain flexibility and leverage when working with major ERP providers?
Well, in this specific case, with SAP, I'll start there, and then I'll talk more broadly about ERP vendors in general. But I think with SAP, you have to recognize that they are, I hate to say it, they're flat out lying when they say that you can't use a third-party process mining tool like a Solonus. Solonus is, we've used Solonus on SAP deployments many times, and it works fine with SAP. When they say you can only use Signavio, they're flat out lying. They just acquired that company not that long ago. That product is not unique, and it was not ever unique to SAP. There's nothing that says that other products can't be used in the same way. But again, SAP's strategy is to tightly control the technology stack that's used by customers and get as big of a footprint as possible. So they don't want you to buy it or use a non SAP product. And, I'd say SAP is probably the most guilty of this in a lot of ways, simply because they are the largest, ERP vendor. Oracle isn't as bad in that way, in that regard, but Oracle is another big vendor. They're more notorious for on the contractual side of things, just really kind of turning the screws on customers with audits and increases in subscription costs over time through those audits. So Oracle has other stiff arm tactics that they deploy that are maybe a little bit different than SAP's, but those two big elephants in the industry tend to yield their leverage, and they use it to their advantage, which, I guess that's the good news, the bad news with these big tech companies. But, and then again, Microsoft being the third big ERP provider, you don't have that problem in that space, just because they are so open and the architecture is open. The ecosystem is open. It's just, for better or for worse, it's a more of a laissez-faire sort of approach to the world that Microsoft takes. Whereas SAP especially is more the command and control, rigid, vendor lock. I mean, they in my opinion, SAP is sort of the definition. They created the need for a definition called vendor lock because that's what they're masters of. Works to their advantage when it creates profits in the short term, but I'm curious to see. I don't think that's a sustainable model longer term. So I think these ERP vendors are going to have to rethink their strategy if they think this whole, forcing customers into certain decisions, if they think that's a good long term strategy. I think they should probably rethink that. That'd be my free advice to them.
Yes, for sure. And speaking of Microsoft, that kind of switches gears nicely into our next newsworthy article of the day. So Microsoft is actually set to raise its prices on Power BI starting April 1st, with an increase of anywhere from 25 to 40% for both Power BI Pro and Power BI Premium. Power BI Pro will jump from $10 to $14 per user, which is a 40% increase. And then Power BI Premium will raise from $20 to $24 per month, which is per user per month, which is 25% increase. So the Microsoft says these price hikes reflect an investment in innovation, but industry experts see it as a strategic push to drive customers towards its Microsoft 365 E5 suite and its new Fabric data platform. I guess the key question here is, will customers take the hit, or are they going to start exploring alternatives? What do you think on that, Eric?
I don't know. That's a good question. I don't know that the customers will necessarily respond by just by moving to another to Office or to Microsoft 365 or any other solution necessarily. I wonder how much of this has to do with the fact that it's getting more expensive for them to maintain all these different tools that they have, and they have to recoup their costs somehow, especially with all the investments they're making in Microsoft 365 and Copilot and some of the other tools that they're investing in. I do think Power BI though just has such a unique niche in the market as far as just people that want that sort of flexibility and obviously data and data management in reporting and analytics, AI, all that's becoming such a big deal in recent years that I can see the value of Power BI being greater now than it was just 5 or 10 years ago. So there's part of me that thinks, well, I mean, it's not, as long as it's justifiable in terms of the business value that companies are getting out of it, I suppose it doesn't matter what they raise their rates to, as long as people can justify it, with the business value. And I've got to assume that, the people I know, or the companies I know that use Power BI or their Microsoft shops, are pretty obsessed with Microsoft, and I think they'll pay more. I think they have a higher tolerance for those sorts of price increases without necessarily getting pissed off about it. So anyway, I don't know. I don't have we don't have a dog in that fight, so I'm a little bit more neutral on that. That the SAP thing that we just talked about, that I have a very strong opinion about this one. Okay, they raise the rates. Either people are going to pay it or they're not, and they'll adjust accordingly, I presume. So we'll see if that forces more migrations to other other Microsoft products, or if it forces them out of the Microsoft ecosystem altogether. Yeah, we'll have to see how that plays out.
Yeah, absolutely. One, I guess, general question I have about this is, I guess we've been seeing rising costs across the enterprise software industry. Do you think this trend is going to continue, and should organizations prepare for future price hikes in their tech stack?
Yeah, I think that they'll have to, partially because all the cloud migration, the whole movement to the cloud, as more and more vendors do it, that just increases costs longer terms or for customers. When you look at the ongoing subscription costs, those add up to more costs over time than your initial capital investment you might have made for an on-prem system. Now, you could argue that business value is justifiable in that increased cost, but the costs are higher for cloud solutions. And now you add AI to the mix, and just the infrastructure that needs to be built to support these robust AI tools. Those are big capital investments for the software vendors, and they are going to pass that on to customers, and they already are passing it on to customers. So I think absolutely you can expect all those things, combined with ongoing inflation and world, macroeconomic uncertainty and things like that. I think all that leads to higher enterprise tech costs in the longer term, for sure.
Yeah, absolutely. Well, interesting to see your different takes on the different newsworthy topics of the day, for sure.
Yeah, interesting stuff. That's really cool stuff, and curious to see how both those things play out, both on the Power BI side of things and with the Solonus SAP lawsuit. We'll have to keep an eye on that as well. Well, good. Well, speaking of lawsuits and legal stuff, we're going to bring on Marcus Harris onto the show next. He's going to be on to talk about some of the legal aspects of digital transformations and some of the legal pitfalls in digital transformations, ERP implementations, as well as AI. And we're going to talk a lot about data privacy, intellectual property, especially in this world of AI and AI being embedded in so much of what we do here today. We're going to get into a lot of that, a lot of stuff here in this interview. So Marcus has been on the show several times, and every time I learn something new, partially because he's a smart guy and there's a lot to learn from him, but also partially because this is all changing so fast. I mean, with technology changes comes legal implications that are different and different legal risks, and in some cases escalated legal risks. So we're going to talk about all that stuff here in just a moment with Marcus Harris. And then later in the show, we'll talk about how and why ERP softwares are the new mafia, in my opinion. This is my opinion. It's not a stated fact. So we'll talk about why I have that opinion and what you can do to mitigate against that risk later in the show. But we're going to take a quick break. We'll be back with more Transformation Ground Control.
Isn't art that's hard to change? Another clever word sets off an unsuspecting hurt, and as you step back in the line,
I'm excited to announce the release of our 2025 Digital Transformation Report. It's available now on the Third Stage Consulting website, www.thirdstage-consulting.com. This report gives you an unbiased, technology-agnostic insight to help you optimize your organization's projects for success. Get your copy today using the QR code in front of me or on our website.
Are you looking for ways to promote your product or service to enterprise technology decision makers and influencers throughout the world, like the ones who listen to this podcast? Major Tom Productions creates media, events, and influencer marketing for B2B technology providers. Our productions are exciting, educational, disruptive, and effective. Most importantly, they create results. Our content is unlike any other in this industry, engaging, influential, and trusted by technology buyers and influencers throughout the world. Each month, our productions reach hundreds of thousands of targeted buyers and decision makers who trust and engage with our honest and tech-agnostic content. With long-tail viral results and engagement with our content, Major Tom Productions provides a way to reach your target market and create awareness, calls to action, and a connection with potential customers. So, collaborate with us today. Learn how we can feature your product or service on podcasts such as Transformation Ground Control, Journey to S/4HANA, and Journey to Dynamics 365. We can also feature your brand on our YouTube channel called Digital Transformation with Eric Kimberling, which boasts over 100,000 subscribers and over 2 million video views per year. You can also participate in our in-person events, including our Digital Stratosphere Conference. Contact us today to learn more. We can tailor a marketing campaign that works for you. We look forward to helping more people learn more about and become engaged with your brand.
with 1,000 lies in a good disguise, hit 'em right between the eyes, hit 'em right between the eyes. When you walk away, nothing.
Hello, welcome back to Transformation Ground Control, episode number 214. My name is Eric Kimberling, here with Darian Chwialkowski. You can find new episodes of this show every Wednesday by going to transformationgroundcontrol.com. And of course, this is the podcast that covers all the technology agnostic aspects of digital transformation, including strategy, people, process, and technology. The show is sponsored by Third Stage Consulting, which is an independent consulting firm that helps clients throughout the world with their digital transformation journeys. And we help clients with digital strategy and software evaluation and selection. We help with implementation planning, phase 0 type of work. We also help with the PMO, change management, and the business process improvement aspects of digital transformation. So if you ever want to talk about your digital transformation and how our team might be able to help you, please feel free to reach out to me or to us. I've included my contact information below. So our first guest for today's show is Marcus Harris, who's an attorney at Taft Law. We wanted to have him on the show again, first time this year, but we've had him several times on this podcast in the past years. to talk about legal aspects of digital transformations. He's been on the show to talk about contracts and lawsuits and failures and litigation and how to avoid litigation, all that sort of stuff. But today we want to hone in on some of the legal pitfalls of digital transformations, particularly in this world of AI and data privacy and all the risks that go along with these new technologies that are coming out. We wanted to really dive into that here with him today. So with that all being said, Marcus, thanks for joining us today.
Hey, thanks, Eric. I always enjoy talking to you about these issues. I think they're certainly timely, and really, there's been a few new developments that I think are substantive that I'm excited to share. I am a partner at a law firm called Taft, based out of their Chicago office. Got a really good view of a green river that they dyed on St. Patrick's Day, which is vibrant green.
Nice.
So I've got a good vantage point here to talk to everybody from. But yeah, thank you for having me. I'm really looking forward to the discussion, and I think it's an important topic that I think it's a difficult topic, but I think it's something that you got to address. There's risks with these things, and the goal for me in having these kinds of conversations is to really kind of cut to the quick and make it easy to understand, so that you can compartmentalize this and focus on what you need to when you're negotiating these contracts and thinking about the larger picture.
Yeah, that's great way to put it and a great way to look at it. And with technology changing as exciting as it is, unfortunately, that comes with a price tag or a risk price tag that people like you can help us understand a little bit more in terms of what some of the risks are and some of the legal nuances are. So I appreciate you being here today. You've been doing this for a long time, though. Maybe tell us a little bit about your background leading up to your time here at Taft Law. I mean, you've sort of seen both sides of the table here in terms of being working in your practice here at Taft, but also being on the side of the vendors as well.
Yeah, I started my practice over 20 years ago. It started out in litigation, and then I moved into working in-house at a couple of different software companies, SAP, and then a software company, SSA Global, which was acquired by Infor. And so, I've got a good understanding based on that experience of how these software vendors operate, what concessions you can reasonably ask, what they are going to give you. I think the hardest thing about this going into these negotiations is, it's easy to see what's in the contract, right? It's easy to see what's on the paper in front of you, but what isn't there that should be there, and what should you be asking for that they're willing to give you, that if you don't, you're just, you're leaving something on the table that you can obtain. And so I think, the in-house experience is valuable. And I think it really enables us to, just get down to business as far as, look, we know you're going to give us this. We don't need to posture. We don't need to push back. This is the reasonable position that everybody agrees to. And, it's a more efficient way to do this, less confrontational.
Yeah. Yeah. And you and I first met in litigation, really. It was one of your litigation cases where you were involved in a lawsuit involving a dispute between an ERP vendor and a customer. And the reason I bring this up is that, you've seen the angle from upfront helping clients negotiate these contracts, but you've also seen the flip side when things don't go so well and things get into an implementation, into a dispute. You've sort of been involved in the trenches helping through that process too. Can you share a little bit about that background as well?
Yeah, that's right. And I mean, I've litigated, hundreds of ERP failures in courts and before arbitration panels across the country. And the interesting thing about them is they all follow a similar trajectory, a similar path. It's the same story over and over and over again. I can have somebody call me, they've had a $30 million ERP implementation failure, and I can basically kind of go through the steps and tell them, what has happened to them, just because it's almost formulaic in the way that these things fail, right? It's the same things that happen almost every time, and the facts are going to be different, and there's going to be a different mix. But generally, we are going to have a good understanding of where the bodies are buried, what was said to the customer, where the failure points are. And it's just a matter of, rolling up your sleeves and getting into the facts and understanding what's specific about that particular failure. But, having the litigation experience with the contract negotiation experience is actually unusual in my field. and they both really make you better. You know, I think when you're negotiating these contracts, you're able to identify provisions that are likely to be litigated, and focus on those, and the other provisions that are less likely to ever come up. I mean, you certainly address those, but you're not going to spend as much time dealing with those. And then I think on the litigation side, you're able to just go through those contracts, find the key terms and provisions, understand how those provisions are going to govern and impact the litigation pretty quickly. So it's a good solid practice. And we've been doing this a long time, really helping, in my view, customers that have been victimized by kind of big ERP, misrepresentations, minimizing complexity, and then lack of experience or abandoning projects. I mean, we see all of these things, and we really do hold these guys their feet to the fire, so to speak.
Yeah, a lot of flawed assumptions go into these contracts or SOWs oftentimes, and we'll get into a lot of that up here, I'm sure, here today. I'll start with the audience, and if you don't mind just dropping in the chat, what do you see as the biggest concern or risk you have from a legal perspective as it relates to whatever initiative you might be working on, whether it's an ERP implementation or some sort of broader digital transformation? Love to hear your comments in the chat on what you think the biggest legal risk is you face, or the biggest legal concern is you have. But kind of shifting that question over to you too, Marcus, what are some of the biggest challenges that you see, just to sort of set the stage here, with all your years of negotiating ERP contracts? What are some of the biggest risks that you see organizations face?
I think you got to look at this in a couple different ways, right? I mean, it's really, what are the risks associated with dealing with ERP vendors in general from a legal perspective, and then what are the risks associated with negotiating the ERP contracts? And I think that's a much narrower question, and that's really changed over time, and particularly over the last, I'd say, probably 3 to 5 years, we've really seen a different emphasis in the way that these guys will negotiate their agreements. And one of the prevalent things that we are seeing on a regular basis in the contracts that we're negotiating is really the presentation to the customer of what appears to be a very simple document. Okay, it will be 2 pages, it'll be 3 pages, and then there is an incorporation by reference of other documents that are found online. And you can't tell on the face of that order form or SOW, how complicated those other documents are, or what the risk associated with them is. When we first started seeing this, it was very easy, at least, to identify the fact that they were incorporating by reference these documents. Okay, what they are doing now is they don't necessarily highlight that it's a URL. They'll just say, oh, and there are these other documents. Now, there's a question as to whether that's legally enforceable. Oracle just dealt with that issue in court as to the enforceability of a reference to online agreements. And so what that does is it really hides the ball. And so you're signing what looks to be a 2 to 3 page contract that's very easy to understand. It lays out all the the dollars and cents and the products. But what you have signed up for, you have actually no idea, because you haven't even really looked at it, right? And no one has taken the time to negotiate it. So, you signed form contracts that are going to be one-sided, unreasonable. They're going to not provide you with any substantive relief in the event that there's a problem, and you didn't even know you did that. And I think that's a huge risk. And they make it seem easy, and you may not even know that those agreements exist. And now you're in a whole world of hurt if something goes sideways. So I think that's something that people just need to be aware of, is to really put the amount of due diligence in these agreements that's warranted. And we see this all the time. You would think, okay, well, it's a $50,000 software transaction where that happens. No, they're $50 million software transactions. They're 60, 70, $80 million is being spent without adequate contract review. And I think that's absolutely malpractice on the part of that company. Some of the other things that we'll see in the agreement specifically are warranty obligations that are hollow. We like to say that a software warranty or a performance warranty with respect to services is really a warranty of time and a warranty of reference. And so what we'll see is some sort of a warranty obligation with respect to that software, but it only lasts for 60 days after the delivery of that software. And what constitutes delivery is not what you think, right? It's the date that you sign the contract. Maybe there's some sort of a download where you get some base code, and you've got a warranty for 30, 60, 90 days, but it's going to take you 2 years to do the full implementation of that software. And now you have nothing. If something goes wrong, you don't have a framework for addressing whatever that issue is contractually. What you're left with is having to sue them in court, which doesn't make any sense, right? I mean, it just doesn't work. We also see broad, I would say, exceptions to these contractual obligations. So sure, we will indemnify you as a vendor, or we will provide you with this substantive warranty where we're going to agree to provide services in accordance with generally accepted industry standards, highest industry standards, professional, whatever it is, or we warrant that the software is going to comply with the documentation. But what they'll put in the agreement is, well, we will do all those things. We'll provide you with a robust indemnity warranty for intellectual property infringement and just a warranty in general, but not if you use it with a third-party product that we don't provide to you, which is ridiculous, right? I mean, you can't.
Right.
That's the way the world works today.
Yeah.
They won't provide you with any of these obligations if you use the product in a way that's inconsistent with the agreement. Who knows what that means? That's open to interpretation. So it's really getting into the nuts and bolts of these things where I think if you're going to summarize it, it's where the vendor doesn't really have any substantive obligations. It looks like they do, but it's all open to their subjective determination as to whether they want to actually do anything or not, and the contract provides them with that out. And that's just not that's an incredible risk when you're dealing with these types of agreements. You've got to have these agreements reviewed. You've got to have them revised, negotiated, and there has to be real substantive contractual obligations on the part of the vendor if you're going to have relief.
Right. Yeah, it's sort of these one-sided nature of these contracts. And that sort of leads to a couple comments from the audience here. And, I asked the question, what are your biggest concerns or risks as it relates to the legality of these projects? Eamon on YouTube says how to build the knowledge needed to review the contracts is one of the biggest concerns he has.
Right.
Sharu has a concern with data moving to the cloud. Most ERPs are on cloud platforms these days. Let's talk about that for a second. Data in the cloud. What does that mean from a legal perspective in terms of cybersecurity risk? Who actually owns the data? What happens if the data is breached? What are your thoughts around data? I know that's a big can of worms.
It's a huge can of worms, right? But I think the risk is real in that the liability associated with doing it incorrectly or having a data security incident or a data breach, whatever you want to call it, there's massive liability associated with that. I mean, if you look at Target, I think Target was $120 million worth of liability for the data security incident they had that I believe was related to an ERP implementation or software implementation. You look at Sony, I think they were around $60 to $80 million in liability. So these things are real and they're going to be a tremendous pain point. And so how do you mitigate that risk? And I think it's really more of a three-pronged approach. First of all, you have to have representations and warranties in these agreements that are real, like we just talked about, where that software vendor is going to step up to the plate and tell you that they are implementing industry standard security protocols. There's an ability for you to audit those practices once a year, twice a year, whatever it is. They are going to have some obligation not to introduce viruses, code that is going to be problematic. And then you've got to look at the disclaimers of liability associated with those. Data loss is something that used to be typically disclaimed But in the context of data security, it's not really reasonable anymore, and you've got to massage that type of language. You also want to make sure that you've got a data processing agreement in place that obligates them to comply with applicable data security laws wherever they're located, right? I mean, typically it's going to be something like GDPR or the California law, or whatever geographic scope that you're dealing with. You want to make sure that those are all addressed in the agreement. You want to make sure that you're only disclosing enough information to that vendor that is required for them to actually do the job. And if they're going to get it, what are they going to do with it? Is it going to be anonymized? How are they going to utilize it? Are they going to train large language models with it? Is there going to be an AI implication? I mean, there's a lot of issues here to unpack, but I think you've got to make sure that there are concrete obligations around data security for the vendor, and you've got to have an understanding of what they're going to do with it. And there's got to be a process for dealing with some sort of data security incident if it should occur. And you also want to make sure that with respect to limitations of liability in the agreement, that they're not so low that you don't have any recourse. Usually you'll have, some flavor of a cap on the direct damages that's tied to the amount of money paid in the last 12 months per SOW per agreement. And then you have to have carve-outs or a super cap for some of these other things, data security being one of them, because like I said, you're looking at $120 million in liability, and if you cap the amount of you can recover from that vendor at the amount of money that you've paid in SOW, probably not going to help you very much.
Right. Yeah. Now, when you mentioned the training the AI models, I want to come back to a question that the audience has here too in just a second. But before jumping to that question, just a real more basic fundamental question. If I'm an ERP customer and I'm buying ERP software, most of these vendors now are building AI into the tool set. Do I have to give permission for them to use my data to train their AI models, or how does that work?
You do, and there's going to be some sort of a provision in those ERP contracts that's going to grant that vendor the right to utilize your customer data in a way that allows them to provide the services. And you have to, there's nuance there, and there's some, fancy footwork that you've got to do to make sure that all aligns. But to answer your question simply, yes, there needs to be some sort of right to access, right to use from you as the customer to that data, so that they can do something with it in connection with that contract. They're also typically going to require that there be some sort of a rep and warranty that you own that data or have the right to it. And if you don't, there's going to be some sort of an indemnity obligation associated with it from you to them, which is probably going to be overly broad, unreasonable, and as expansive as you can imagine, wherein as their indemnity obligation to you is going to be incredibly narrow and ineffective.
Right. Now, what about this? Speaking of AI, here's another question. This is a great question from Darian on LinkedIn. She says, with the rise of AI-driven ERP solutions, do you see vendors shifting even more liability onto customers for AI-related errors or misinterpretations? So AI, in other words, has a delusion, it's delusion, delusions in it or whatever, or misinterpretation of data. Is that risk you, the customer, or is that risk the vendors, or both, or how do you view that?
Well, I mean, I think in the ideal world, as a customer, you're going to want to put most of that risk on a vendor, and from the vendor's perspective, they're going to want to put most of that risk on you, right? And so there's got to be a middle ground where there's a reasonable allocation of the risk that is associated with faulty performance of that AI model. And usually the contractual framework that we use for software in general is going to be the model that you're going to use to address it. But certainly there's going to be a reluctance on the part of that vendor to have much responsibility for the outputs, right? And they're going to try to put as much responsibility on you for how you're using that AI functionality. Certainly, you need to be responsible for the outputs that are being generated. There's going to be issues around indemnification, especially from an intellectual property standpoint. And this is a very valid issue that comes up pretty frequently right now, is how do you obligate that vendor to represent that they own, the data that is being used to train that large language model, especially if it's an open model and they're just getting it off the internet. There's got to be some sort of a representation that they've got at least a right to utilize that. But good luck trying to get them to indemnify you for infringement. It's going to be challenging. We've got certain strategies that we've developed over the last couple of years that we're utilizing with particularly AI vendors, and certainly with ERP providers that incorporate AI functionality into their contracts. But it's a minefield right now of legal liability and negotiating these contracts to try to be reasonable. And I think the larger AI providers that we've dealt with are pretty balanced and reasonable with the way they address these issues.
Yeah.
And I'd say it's the ERP providers that are difficult.
I'm sorry, say that again. It's the ERP providers.
The ERP providers that are incorporating AI functionality into their product, they're a little bit more difficult to deal with.
Mm-hmm. Yeah.
It's something like OpenAI is generally pretty reasonable in negotiating their contract, where somebody like SAP is, seems like they're consistently trying to hide the ball, and they've got language in there that allows them to modify the contract at their discretion unilaterally to address changes in AI functionality going forward. And it's hard to beat that back sometimes.
Yeah, that makes total sense. I want to say hello to Sandra, who's joining us here from Chicago. Thanks for being here, Sandra. So along those lines, then, what about, you said the ERP vendors are a little more difficult to deal with than, say, an OpenAI or some of the AI specific vendors out there. What about, not just in terms of contract negotiation, but also in terms of data ownership or intellectual property, I should say. And let me try to phrase this in a layman term sort of way. But when I've got data within my organization and I'm using it within an AI model, let's just say I've given permission to the vendor to use my data to train its AI model and whatever results I get back from it. Do I still own that data? Have I given up some sort of ownership of that data, or how does that work? Because I've read recently how you can't get a copyright on something that AI helps you write, and so there's intellectual property issues there. But what about if it's already my data? It starts off as my data, but then I use it to feed an AI model. Do I cede any sort of control or ownership of that data and intellectual property?
You very well might. And the problem with that is, if there's no transparency in this open system versus a closed system that's where the large language model, for example, is utilizing your own data to train that model, that's a different story. In the context of an open AI model, where your data is being mixed in with hundreds of others or thousands of other customers, and the data that's coming out, what is the ownership interest in that data? That's a very good question. And you're absolutely right, Eric, when you say that information is not copyrightable. And there's some nuance to that. I mean, if there's substantive human involvement, and I'm speaking generally right now, then certainly you could get, the case law suggests you certainly can get some sort of copyright on that if there's human intervention, human involvement with the output at some point. But if it's simply machine generated output, if you can't even get a copyright ownership interest in it, what's the ownership associated with the output in general? I mean, certainly you own, or you should, and the contract should address that you own the underlying data, right? But what the ownership structure associated with the output is not always clear. And I think when you're negotiating these contracts, you need to make it clear. And it's going to be dependent on the type of large language model, the type of AI functionality that you're dealing with and what it does specifically. So, it's not an easy question to answer, actually.
Yeah. I was hoping for that easy answer, that one size fits all answer.
Well, yeah, consultants and lawyers like to say it depends, right? And there's unfortunately some validity to that.
Yeah. I know I keep asking you some of these questions in different, I'm framing it different ways, wording it a little bit differently, hoping I get that easy answer, but it usually comes down to, it depends.
Yeah.
After all these years of knowing you, I should know that that's the answer we're going to get, but it is true. I mean, it just goes to show though, how much this stuff changes, and with technology changing as fast as it is, that means the legal implications are changing quickly too, in terms of some of the stuff you've got to look for in contracts and whatnot. How do you see, do you see any sort of material impact of AI on, let's just say, the success or failure or risk level of these sorts of implementations? Have you seen enough data? Are we far enough into the journey to know yet how AI is going to affect the legal, or not the legal aspect, but just the risk level of these projects?
Well, I think that's a really interesting question. You can deal with that question in a couple of different ways. And one is the utilization by the implementation team of artificial intelligence tools or functionality to help them implement, integrate, customize, and modify that ERP system. And I think there's a tremendous amount of risk associated with that, because who knows what they're utilizing, what kind of rights they have in that functionality. Are they going online and basically copying code? And again, what's the ownership interest in that code, and is it infringing if you can't even get a copyright in it? I mean, these are nuanced, roundabout kind of questions that are incredibly interesting, certainly to lawyers. But yeah, I mean, I think the utilization of artificial intelligence in the implementation process itself, I think, creates substantive risk. And you've got to address that, with the warranties and representations and limitations of liability and indemnity provisions that you put in those consulting agreements, those MSAs, and to make sure that you've got meaningful relief if something happens, whether it's just a standard contractual breach or it's a breach associated with the use of artificial intelligence. The other way to answer that question is, what risk does the incorporation and utilization of artificial intelligence into the ERP product by the customer, or the use of it by the customer, what risks does that carry? And I mean, I think it carries a tremendous amount of risk, depending on what the nature of that functionality is exactly, and how you're using it, right? I mean, if you're using it in connection with making decisions about hiring or firing, that's going to present a certain type of risk that's going to be different if you're using it to automate the process of the review and processing of invoices or something, right? So the use case is going to dictate the risk, but I mean, there's a tremendous amount of risk associated with it. I mean, you've got to look to things like, are we going to accidentally disclose trade secrets? Are we going to be incorporating confidential and proprietary information into the AI model? The copyright infringement, something that you referenced a second ago. What kind of algorithmic bias are we being subjected to because of the AI model?
Yeah,
and I think having an understanding of the transparency associated with the algorithm, depending on what you're utilizing it for, is going to be important, and putting that kind of language in the contract so that you understand what you're getting yourself into and where the risks are, so that you can mitigate those risks within the body of that contract, is going to make a lot of sense.
Yeah, that's super interesting. And I also wonder, I suppose this isn't so much a legal angle as it is just more of a business competitive angle, but I do wonder over time, what does that mean if you've got, let's just say you're using SAP and you're training SAP's LLM to give you your AI outputs that you need to, make decisions or to run your business. And every other competitor in your industry, or a bunch of other competitors in your industry, are also using that same AI model. Does that just sort of water down your competitive advantage now? And who's the real winner here? Is the winner you, the customer, or is the winner going to be SAP in this case, or the software vendor, because now they've got all this data and this mass, really cool, well-trained AI model, which is great for SAP, but is that great for you as a customer now? You've just sort of like given up your core competitive advantage potentially.
Yeah, no, I think you're right on with that analysis. And I think for me, the way that I would view this is, I mean, I think the winner in that scenario is the software vendor. They're getting all, this information, the data, the processes They're understanding, how their customers operate. And one of the things that we have been seeing, I would say really in the last 2 years, and certainly more now, is when we are negotiating these contracts, these vendors are trying to very much put a fence around the data that you have incorporated into or input into their system. And so if you remember, about 5 years ago, maybe it's a little bit longer than that, there was this whole indirect use concept associated with SAP, where if you had another piece of hardware or another piece of software that was actually interfacing and pulling data from the SAP system, that would count as a user. And it would count against your license metric, and there would be fees that would be due to SAP for that. And they very much want to do that with your data. And so, if you're going to put that data into, we'll just use SAP as an example, into SAP, you have to make sure you understand what fees are they going to try to generate from your utilization of your own data to train third-party artificial intelligence software. Okay. I mean, because this is a repository of all your data anyway, I would assume, right?
Yeah.
And so now they're trying to extract additional money for you to be able to utilize that data to do other things with it outside of that SAP ecosystem. And, where's the value add for that? I don't know, but it's certainly going to be expensive. And you got to look at that contract very carefully to make sure that you understand their ability to charge fees for that and the fee structure that's going to be utilized to extract additional fees from you.
No wonder the vendors love AI so much.
Yeah.
all the stuff you're saying is like, well, yeah, no wonder they're investing so much money in AI, because they're making a good amount back on that.
I think, yeah, definitely. I mean, you look at this, and I look at a lot of this AI stuff as kind of a shiny object, right? It's a lot of sizzle. Maybe it's not a lot of stake right now. It's hard to tell, but everybody's trying to sell you artificial intelligence. And okay, well, what can you really do with it in some ways? I mean, it's some of the things you can do with it are incredibly amazing. I mean, if you look at hyper automation, robotic automation process. I can't remember the
RPA, the robotic process.
Yeah, robotic process automation. I mean, these things are amazing, right? And you're taking everyday tasks that you do on a regular basis, and now you're automating it at a huge high level. I mean, certainly that's an incredible thing to be able to do. But in some context, I mean, AI is okay. Well, where's the value add for it, really? It's not always there. But for the vendor, it is, right? They're getting all your data.
I'm here with Marcus Harris. We're talking about legal pitfalls in digital transformations and ERP and AI. We've got a lot more to cover, but first we're going to take a quick break. We'll be back with more Transformation Ground Control.
My name is Eric Kimberling, and I'm the CEO and founder of Third Stage Consulting. Before we dive too far into today's content, I want to invite you to learn a little bit more about Third Stage Consulting, who we are and what we do. I've included a link to a video right here that describes Third Stage in a bit more detail. It talks about our story, our history, our philosophy, our clients, our service offerings, and that sort of thing. But in general, what Third Stage Consulting does is we're an independent and tech-agnostic consulting provider. We help clients through their entire digital transformation life cycles, beginning with digital strategy, software evaluation and selection, all the way through and including implementation planning, implementation readiness, and the actual implementation itself. We're technology agnostic, so we only represent our clients' best interests. We do not represent software vendors. But having said that, we work very closely with software vendors, all the leading players that you can imagine we've worked with, both in helping clients evaluate and select them, but also in helping clients implement those solutions as well. So we have a very broad, objective, agnostic view of the market that is meant to really represent your interest as you go through your digital transformation. I also encourage you to scan this QR code right here to get access to our resource center. This resource center has a ton of information, a ton of ebooks that are free. You have access to top 10 software rankings, playbooks for how to make your project more successful, guides to change management, YouTube videos, all kinds of stuff that are going to help you through your digital transformation. So I encourage you to scan this QR code to get access to those resources. And please feel free to reach out to me directly to brainstorm ideas about your project. Even if it's just informally, you want to bounce around some ideas and get some informal advice, I'd be happy to spend some time with you. So feel free to reach out to me. I've included my contact information below. You can also find it in the description field of this video as well.
The last thing you want to have happen is for your digital transformation to end up in court. I've been doing this for 20 years and I have seen everything. My name is Marcus Harris. I'm a software and technology attorney focusing my practice on drafting and negotiating software-related contracts and litigating software disputes across the country. Feel free to reach out to us at taftlaw.com. We'd love to talk to you about the litigation process and what you can expect.
I'm gonna leave it all out there. I'm gonna leave it all out there. And I'm gonna leave it all out there.
Hello, welcome back to Transformation Ground Control, episode number 214. My name is Eric Kimberling, here with Darian Chwialkowski. You can find new shows every Wednesday at transformationgroundcontrol.com. You can also see all the past episodes we've produced at transformationgroundcontrol.com as well. The show is sponsored by Third Stage Consulting, which is an independent consulting firm that helps clients through their digital transformation journeys. And I'm here with Marcus Harris. We're talking about the legal pitfalls of digital transformations. I don't know if you saw it, but we had Jan Bond was on this show just a couple weeks ago, and he's the one that founded Bond Software, which is a big ERP provider back in the 80s and 90s. They were a prominent ERP vendor, and now he started another company, more of a microservices composable ERP sort of tool set. Anyway, he was on the show and he was adamant about how your AI should never be within the ERP system. The ERP system should just be basically the transaction of record, and then you want to layer on top of that an AI model that you own, you control, not the vendor. And there's something to be said for that. I thought he had a pretty compelling argument, because you do think about, well, if data is a really important asset to me as an organization, and I want to be able to make decisions better than my competitors, why would I just give all that up, to a big software vendor who now makes that commercially available to every other competitor and non-competitor out there?
I could not agree more. I mean, I think you're ceding control over one of your most valuable assets to a third party that's going to then charge you to be able to utilize it in a way that you want to, right?
Yeah.
And one of the core tenets I go by when I'm reviewing, negotiating these contracts is to get as much flexibility as I can for my client in the way that they're going to utilize this software. So it's either a license, like a traditional on-prem license, it's an access to a cloud solution, but the goal is to get all the indicia of ownership within the constraints of that contractual framework, so that you don't have to pay additional fees for utilizing the software in ways that make sense for you. And it's even more true with your data. I mean, you don't want to give up ownership of your data, which you aren't necessarily giving up ownership of it, but you're giving up flexibility, and you're subjecting yourself to fees for the use of something that is yours.
Right.
I mean, it doesn't make any sense.
Yeah, it doesn't make any sense. But when you're a big ERP vendor and you have that sort of control and lock-in of customers and that sort of thing, I guess you can do those sorts of things because you can.
Absolutely, right. I mean, you're kind of at the mercy of these ERP vendors. They're the only game in town.
Right. Here's a really interesting question kind of related to that. And I had never thought of this question before, but I think it's a brilliant question. This is from Emerson on YouTube. Emerson says, will independent AI organizations also develop parasitic relationships that also provide lock-in across verticals and horizontals? So in other words, if we do what we're saying, or what Jan Bond would suggest, or what it sounds like you might be suggesting too, if we say we're going to use a separate AI tool set to sort of bolt on to our existing technology stack, whatever that is, will that AI vendor then just become the next big ERP vendor to now get us locked in and hard to get out of? What are your thoughts there if you had to predict the future?
I would be pessimistic, and I would say absolutely that's what they're going to want to do, right? Because that's where the fee generation is. If they've got a lock on your data, and they can make a reasonable argument that there's some value add that you need to pay for in order to utilize that data with a third party product, they're gonna find a way to get that money from you. And I think that's a great way to say it. It's a parasitic relationship, right? And Jan Bond is absolutely right. Like, why on earth would you put all of the sensitive data into your ERP system and give up maybe not ownership of it, but control over it.
Yeah. Now, what about kind of coming back to the point you were making earlier around training AI models? I know this is asking you to give sort of a legal recommendation when you don't have all the facts, which I know is something that drives attorneys crazy. But just in generally speaking, would you advise to embed and reserve rights to train AI on anonymized data in the contracts, or give away to opt out? How do you negotiate that piece of it?
Well, I mean, I think if it's going to be, data is a broad word, right? But certainly if it's going to be personally identifiable information that you have an obligation to protect in connection with data security laws and regulations, then you're most likely going to want to utilize best practices and anonymize that data to the extent that you can. I mean, can it be de-anonymized? Probably, but you've got to put contractual framework or restrictions around that vendor's ability to do that. But I think certainly to get the value out of that AI functionality, you're going to have to give something up, right? And I think putting anonymized data is probably the way to go, because at least it's going to allow you to assert that you've complied with your data security obligations. And I mean, maybe you're giving up less control of that data. I don't know.
Right. Yeah, very, very interesting. And a couple different angles I hadn't thought of before here, as it relates to this. Are there any other anything else we haven't talked about as it relates to AI adoption and some of the legal risks associated with it? Is there anything else kind of low hanging fruit we should be aware of when we're negotiating these contracts?
Yeah, I mean, I think there's just a ton, and it's hard. It's such a broad question. I think you've really got to be concerned with, just as a general tenet when you're talking about artificial intelligence, it's data security. What happens to your data? Are you disclosing inadvertently proprietary information, confidential information, trade secret information that you can't get back, right? What are implications for intellectual property infringement and intellectual property protection? You talked about it's kind of watering down and making a level playing field for everybody, but if you're trying to protect the output that you're getting from utilizing your data in this AI functionality, if it can't be copyrighted, how are you going to protect it, right? I mean, what competitive advantage are you actually getting from it, and how are you able to exploit that and capitalize on it versus your competitors? Everything they're now having the same information, right? You have to have some level of transparency about what is that vendor doing from a safeguarding aspect with respect to your data and your information. You have to have an understanding of how that algorithm might work. You want to understand bias issues. You can't have an over reliance on the AI functionality in general. I mean, you've got to have some human involved in that process in some way, shape, or form to be able to just double check to make sure that this is accurate. And certainly from an intellectual property perspective, if you're trying to protect anything, you're going to want to have substantive involvement from a real person, that's making decisions about, how to incorporate, how to select, and how to modify.
Yeah. Very interesting. What about the cross-border data transfers? So if I'm a multinational organization or if I'm a domestic organization, do I need to worry about where the data goes?
You do, and I think you've got to really have some understanding of the geographical reach of how you're going to utilize that information, right? So I think where are you getting it from? So I mean, if you're a global company, which affiliates, which subsidiaries, which offices are you collecting information from? Okay, because each one of those jurisdictions is going to treat data security or data security obligations, privacy issues associated with it. They're all going to be treated slightly differently. There's going to be some overlap, certainly, and I think the default for a long time has been, if I comply with the strict regulations of GDPR, I'm going to be generally okay. And I think there's some value to that, but you still have to have an understanding of, what geographic regions are you collecting from? Where do these people live? What laws are they subjected to? And it's not even just with respect to foreign countries. Okay, so you're gathering information from the EU, but what about China? What kind of personally identifiable information regulations are currently in place, in whatever jurisdiction that you're dealing with? California, EU, okay, well, those are kind of, well settled, but, there are new state laws coming online all the time, right? And that's not just with data protection, it's also with artificial intelligence,
Yeah.
I mean, you've got, don't hold me to this, but I think it's about a third of the states have enacted some sort of, comprehensive data privacy law. Okay. And if you're operating in those states or between those states, you're going to have a pretty good understanding of what your legal requirements are. And there is going to oftentimes be some sort of a representation or warranty in that agreement that you're going to comply with those laws. I mean, you have that obligation anyway, right? But you have to do the due diligence to understand, where you're sending this data, how it's being sent, who owns the data, or who has rights to that data. And it's not always easy sometimes, especially if you're a multinational corporation with, multiple different offices in different countries.
You're making me wonder if any or if many organizations out there that are in the process of negotiating ERP contracts or any sort of enterprise technology contract right now, presumably it involves AI, because so many of these products have embedded AI, and these data privacy laws continue to evolve. I wonder how many organizations have actually thought through this stuff that you just talked about. I mean, because I feel like it's not top of mind for a lot of organizations. I feel like a lot of organizations just sort of march forward, sign the contract without really realizing what this all means long term.
I think the sophisticated ones are getting there. I mean, and you've got to understand. I mean, when we started our conversation, you've got companies that are signing agreements without actually fully reviewing all the contracts that are referenced in those contracts, right? I mean, they're signing an order form that has about 70 pages of terms and conditions that nobody looked at. Those people, are just asking for a lawsuit, basically, right?
Yeah.
But I think the more sophisticated companies that have a reasonable due diligence process in the evaluation and the selection of the software are actually thinking about this. Not as much as they should. I think they're looking at it from, okay, where are we having distribution centers, right? Where are we going to be utilizing the software? They're not so much looking at it from, hey, we've got a subsidiary in Canada, we've got an affiliate in Mexico, and all that information is coming into the United States. They're not really thinking about it that way. They're thinking about it in a collateral way. Where do we have warehouses? Where do we have distribution centers? Where are we located? And what kind of what kind of impact does it have on the fees that we're going to be paying that vendor, right? And then I think they start thinking about their data security obligations in those different jurisdictions.
Yeah.
But still not substantively.
What about so we've talked about the sort of the contractual vendor facing side of some of these contractual and intellectual property data privacy sorts of issues. What about though as it relates to our employees? Let's just set aside the vendor facing side of things and just talk about our own employees internally. What should we be thinking about when it comes to data privacy? What happens to data in these AI models? Is there, are you seeing any sort of impact on the employment expectations or the employee-employer expectations in that relationship to protect data, to have guardrails around how AI is or isn't allowed to be used within the organization? How are you seeing that unfold?
It's a little bit of a different scenario. And I think from a data protection standpoint, your obligations are your obligations, right? And whether it's a customer or an employee, if you've got personally identifiable information that is subject to data security regulations or laws, you've got to comply with those obligations. And it's not really going to matter so much if it is an employee or a customer. I think from a broader perspective, as you're looking at the employees and their utilization of artificial intelligence, I mean, I think you have to make sure that you have some sort of an AI policy in place, and that dictates what they can and can't do with artificial intelligence functionality. Whether they're pulling it off the internet and utilizing publicly available, sources, or if it's proprietary and it's embedded within the ERP system. I mean, do you actually need to utilize it, right? And what are you need to have a review of what your business processes are, how they can be enhanced by artificial intelligence, and then have some sort of policy in place that puts some guardrails around, what is acceptable use associated with artificial intelligence. And you don't want people putting in sensitive information into some sort of publicly available artificial intelligence functionality that they've got off the internet, right? I mean, there's significant liability associated with that, and they should only be able to use approved pieces of functionality, AI products, and only for a defined set of uses. And the company should dictate what that is and enforce it.
Right. And set those operating procedures and get those in place so that employee handbooks, all that stuff I would imagine needs to be updated with.
Absolutely. And that's, everybody needs to have that right now. And that's, we just did an acceptable use policy with respect to artificial intelligence for a hedge fund. And, there were certain things that their employees could use AI for, and there's certain things they can't. And, the dilemma, I think, for an employer is, especially employers that want to embrace technology and view it as a cutting edge differentiator in their marketplace from their competitors, is how do you promote the use of artificial intelligence and not restrict it too much, right? You've got to limit your liability, but you still want to promote innovation, efficiency, and the utilization of this kind of technology. But there's got to be some sort of a balance, because you've got to limit your liability with respect to it. So, I think what was it? Was it Walker
Reynolds?
Walker Reynolds, right? I think he was at a conference, your conference, and I was listening to his talk, and I think he said that every one of his employees has ChatGPT up, and on one screen while they're doing their work. There's value to that, certainly, but there's tremendous amount of risk, right? If you're not monitoring what they're doing, you're asking for trouble.
Yeah, especially if you're dealing with confidential information, or if you're a consultant, and you're working with a client and you're using their information. What liability are you exposing them to? What liability are you exposing yourself to? I mean, there's so many people touching your data that might also be touching AI.
Exactly. Right.
First, to see where that goes, what some of the implications are longer term with that trend.
Right. And I mean, you've now introduced your client's data into a large language model that's being utilized to train their competitors, and the introduction of that data can be traced back to you, and it was proprietary or confidential. You've got significant liability right now.
Yeah. Now, what about given all this? Well, before I ask you this other question, I'll ask you a different one. If a company does find itself in some sort of legal dispute with the ERP or AI vendor, what immediate steps should they take? And we haven't really talked about legal disputes yet, but let's assume that something happens with these contracts, something gets sideways, they didn't negotiate something right up front, or your vendor doesn't deliver as promised the way they said they would, or you think they should have. You find yourself in sort of a potential legal dispute. What do you recommend as a first step there?
Yeah, I mean, well, the absolute first step is preserve all your data. Okay, all the communications. You want to put a hold on deleting anything that's related to that project, that implementation, and make sure that you preserved it so that you can utilize it later. All right, and that could be anything from text messages to recordings of Zoom meetings, Teams meetings, whatever you're utilizing. But all that needs to be preserved. And then the second thing I think you really need to do is you have to have a cost benefit analysis. I mean, is this project savable? Okay. Can you salvage this? Have you lost all confidence in this vendor's ability to do what they said they were going to do? Right. And, as I always say, that, these things don't fail. You don't get into legal trouble normally because the software doesn't work. It's the implementation and integration of that software that causes the problem. And, have you lost all faith? Can you turn this thing around? And if the answer to that question is you can turn it around, we still have some level of trust in this vendor, I think you're going to want to do everything you can to get that project right-sided and avoid a legal dispute. And the reality of this is you spend $20-30 million or more on an SAP Oracle system, or whatever vendor it is, and you sue them, they're not going to take that lightly. They are going to push back hard. This is serious litigation. They're going to have huge law firms on the other side. It's not something that you do lightly. You're going to be focused on depositions. You're going to be, going to court hearings. You're going to be spending a tremendous amount of money in legal fees. And I think the legal fees that you can expect to spend, if you're having a real substantive dispute that goes very, very far in the legal process, up to trial or even a trial, I mean, it's not going to be cheap, and it's not something you're going to want to do, and the outcomes are almost always uncertain. So, I think, think about it very carefully, and if you can resolve this on a basis that keeps you out of, a lawyer's office, that's the way to go.
Yeah, and of course, a lot of this all begins with where we began this conversation, as far as negotiating the right contracts, making sure you're all on the same page and have a clear understanding of the assumptions behind the agreement and the T's and C's of what's in the agreements you're signing with the vendors. It all sort of starts there. So if we sort of back up even more and say, let's assume we all want to avoid litigation. We don't want to let it get to that point. What can or should we be doing early on, when we first start a project like this, or we first start the procurement cycle with the software vendor? What should we be doing from a negotiation perspective? Because you've given us a lot of good advice, good takeaways here. But how do we get started on that journey if we know we're about to engage with a software vendor?
Well, I mean, I think it starts at the selection phase, right? And you have to have an understanding of the business processes that you need to improve. An understanding of where you're at today and where you want to be at after you've implemented the software, right? That is key to understanding, the value you're going to get out of it. You have to go into this thing with realistic expectations. You have to know that it's going to take a long time. It's going to cost, much more than you think it's going to cost. It's going to be more complicated. And you have to take everything that vendor says with a grain of salt. You can't trust them, unfortunately. I mean, when they say, look, this is an out-of-the-box solution that is designed for your industry, it contains industry best practices, that's probably not true, okay? And they're saying that to minimize the complexity of that implementation project, to get you to sign on the bottom line. And you've got to go into this thing asking the right questions, doing the proper due diligence. You've got to, conduct site visits, software demos. You've got to be able to know how to utilize all of those tools to your advantage, because the cards are stacked against you, right? And you can do all this stuff and still end up in a problem. And then once you start negotiating contracts, you really, I think the most important document that you're going to negotiate is the two. One is the MSA, okay? And the second one is going to be that individual statement of work or statements of work that govern the project. And those have to be detailed and specific. They've got to have meaningful deadlines. They've got to have meaningful milestones, acceptance testing. All of these things have to be spelled out with a lot of specificity. The challenge that you have with negotiating those is that I think most statements of work are really a snapshot in time, right? They're done at the beginning of the project. And while there's going to be, or there should be, some mechanism for utilizing change orders as that project changes over time, you can't manage via change order. And I think you've got to look at the project plan, have some insight into how that works, work with the vendor on that project plan, be involved in the process and incorporated by reference as part of the contract. And ideally, any representations that were made to you get you to get into that contract should be incorporated by reference as well as either warranty obligations or some contractual obligation, so that it's all all buttoned up. And, it's not easy to do all that. Vendors don't want to.
Right.
You got to give yourself a dog in the fight. And
Yeah.
the contractual process is the mechanism by which I think you can do that.
Yeah, and it'll protect you from having to hire you as someone to help litigate or defend in a lawsuit versus just hiring someone like you to get it all buttoned up front.
Right. Absolutely. I mean, spend the money up front because you're going to spend a lot more money on the back end. The goal with negotiating these contracts is to be able to put them in a desk drawer, pull that out 2 years, 3 years into the implementation when something isn't going right. Look at, clause 5, section 1B and say, okay, well, we anticipated this. And when this happens, we're supposed to do this and you're supposed to do that. Ideally, there's going to be some contractual framework for resolving that issue and detailing whose obligations are whose. That's what you want, right? You don't want some generic form agreement that everybody signs that doesn't help you at all.
Yeah. I love that in a couple of your responses, including this last question I had just asked you, in the background, you could hear sirens, these ominous sirens, like fire trucks or whatever you could hear through your office there. It was very, did you plan it that way to, as you're talking about the risk, the legal risk, you could hear sirens in the background, which made
No, I wish I did. It's a nice soundtrack, to make you take these things seriously. Unfortunately, I'm in Chicago downtown. And so I don't even hear them anymore. So
yeah, just used to it. Yeah.
I'm just used to it. Yeah. Which is a good metaphor for these lawsuits. I mean, you're just used to dealing with this chaos, and that's what you need, right? You need somebody that's objective, that's not going to be intimidated by the vendor, that's not going to be susceptible to, the vendor false sense of urgency associated with getting a deal closed by the end of the month, the end of the quarter, the end of the year, the threat that all these discounts are going to disappear. You need somebody that can stand up and guide you through this process. And it's not just lawyers that do that. It's also people like you. It's, the software selection consultants, people that are going to negotiate the business terms specifically, that you can hire people like that. There's a team of professionals that you can utilize and you should utilize if the deal size is big enough.
Yeah. Well, you've established yourself as quite the thought leader in this space for people that maybe they're not quite ready to reach out to you, have a direct conversation yet. How could they follow you on? I know you've got a YouTube channel, LinkedIn. What are some of the best ways how can they find you in some of the content?
Yeah, I mean, you can find us on our socials. It's Marcus Harris Attorney or Software Attorney, Marcus Harris Software Attorney. If you put Marcus Harris in, you're going to get an NFL player, which unfortunately my NFL playing career is probably not going to happen anymore. Probably a little late for me, though I had big dreams at one point.
You still have time.
We always have time, right? Your MBA career is probably in the not in the rear view mirror, but in front of you as well. And
being 5'9", I'm a perfect prototypical NBA player.
it could be a shooting guard, maybe, I don't know, a point guard. But yeah, Marcus Harris, Software Attorney, is going to get you to our YouTube channel, our LinkedIn. It's going to get you to TikTok and Instagram and Twitter, Blue Sky. I mean, it's we're virtually everywhere. So there's a lot of good content on our channels, long form videos, short form videos, and I invite you to, if you're not ready to have a live conversation, I mean, take advantage of that. It's a good resource, and it walks through a lot of these things in more detail, in a way that I hope is easy to understand and digestible.
Yeah, I was just going to say those exact words. The content you put out is, well, first of all, I'll say you're the only attorney I enjoy listening to. And I mean that there's no other attorney I want to listen to, which I don't know if that's a compliment to you or an indictment on your profession, but
it's a little bit of both, I think. Yeah.
Right. I'm kidding, but I do actually I really like your content because you make it so easy for the lay person to understand. It's not, as smart as you are with the legalese, obviously you have a way of sort of dumbing it down for people like me that don't understand legal stuff. So I do recommend you follow your TikTok channel. Your YouTube channel is really good too. You put a lot of effort into that, especially recently. Well, thank you again, Marcus, and thank you to the audience for the great questions there. Really appreciate your time and great questions and comments here today. We've got a lot more to cover here. We want to dive into some of that discussion with Marcus and just follow up on a couple threads that he brought up here during that conversation. And then we also want to get into why ERP software vendors are the new mafia. So we'll get to all that and more here in just a few moments. We'll be right back with more Transformation Ground.
If you are involved involved in any sort of digital transformation or business change initiative, you will want to download the Digital Transformation Report. With its comprehensive overview of business and technology trends and best practices, this report is a must-have guide for any transformation project or executive team. Download this free report by visiting Third Stage Consulting at thirdstage-consulting.com. You can also visit our website to learn more about us or download independent reports, videos, and other best practices. Again, visit thirdstage-consulting.com today to learn how you can take your transformation to the third stage of success.
Are you looking for ways to promote your product or service to enterprise technology decision makers and influencers throughout the world, like the ones who listen to this podcast? Major Tom Productions creates media, events, and influencer marketing for B2B technology providers. Our productions are exciting, educational, disruptive, and effective. Most importantly, they create results. Our content is unlike any other in this industry, engaging, influential, and trusted by technology buyers and influencers throughout the world. Each month, our productions reach hundreds of thousands of targeted buyers and decision makers who trust and engage with our honest and tech-agnostic content. With long-tail viral results and engagement with our content, Major Tom Productions provides a way to reach your target market and create awareness, calls to action, and a connection with potential customers. So, collaborate with us today. Learn how we can feature your product or service on podcasts such as Transformation Ground Control, Journey to S/4HANA, and Journey to Dynamics 365. We can also feature your brand on our YouTube channel called Digital Transformation with Eric Kimberling, which boasts over 100,000 subscribers and over 2 million video views per year. You can also participate in our in-person events, including our Digital Stratosphere Conference. Contact us today to learn more. We can tailor a marketing campaign that works for you. We look forward to helping more people learn more about and become engaged with your brand.
Hello, welcome back to Transformation Ground Control, episode number 214. My name is Eric Kimberling, here with Darian Chwialkowski. And Darian, we just had Marcus Harris on the show to talk about some of the legal implications, all the legalese and the stuff that we don't always want to think about during digital transformations. It's probably not the most fun part of digital transformations to think about, but what were some of your thoughts and takeaways from that conversation?
Yeah, I mean, it was a really insightful conversation with Marcus. I feel like it always is. Like you said, we always learn something new from him. I guess a few things really stood out from me specifically. One of them being, he just kept reiterating that one of the biggest things about how risky ERP contracts can be is if companies don't do their due diligence. So one thing you mentioned multiple times was vendors often present super simplified contracts and then that are just a couple of pages and then bury all the real applications in a reference document online. Have you specifically seen companies get burned by this? And what's the best way to make sure that they're not signing something that locks them into bad terms?
Yeah, we have seen that a lot, and Marcus has worked with some of the same clients we've worked with, so we've sort of seen the same situation in many cases. But the thing that the one that's the most concerning to me is and he didn't really talk a lot about it this time, but in past interviews I've had with him, he's gone into more detail. But that URL link that you agree to in a contract that says basically, here's the contract you're signing, here's a URL link to our terms and conditions, and by the way, we can change that set of terms and conditions unilaterally without even notifying you, and you are still agreeing to them. That's the most alarming part, because you're basically ceding complete control to the vendor to basically do whatever they want and to change the terms and conditions as they see fit. None of this is really an issue as long as you don't end up in litigation or you don't end up with a problem on your hands. I guess that's the first thing. But the problem is, what if you do end up in litigation? That's where it becomes a problem. So for most people, it's going to be okay. But for those that don't, where there is a problem, that's where you've got issues. Now, I think the one thing we didn't get into in this interview, another thing we didn't get into in this interview, but we have in other interviews with Marcus, is that these lawsuits are so complex and so complicated, and there's so many different things that come out during these lawsuits. I mean, there's so many reasons why these projects fail that even the tightest terms and conditions in a contract aren't going to save you or the vendor from any sort of legal liability there. So I'm not saying it doesn't matter, because it absolutely does matter, but usually it doesn't just come down to a set of clauses and T's and C's. It's usually a bunch of stuff that, has to be sifted through. And it's a very long, cumbersome, and expensive process that I highly recommend you don't get involved with if you can avoid it. So I would just say, like Marcus said, just get all that stuff nailed down up front. One thing I know he's done is I've seen him negotiate with some of our clients. He'll negotiate where you aren't agreeing to this URL link that points to a living document that could be updated at any point by the vendors. He actually will have, I've seen him talk about how he will actually take a snapshot of those T's and C's, and that's what you're agreeing to, and any changes don't necessarily apply to that customer. The problem is, if you're a really small customer working with a really big vendor, you might be outgunned in that regard with your own internal legal counsel. And you might need someone like a Marcus to help you negotiate that, or have the leverage to negotiate that. Bigger companies are more likely to get those sorts of concessions, but you also have to look at the relationship and your leverage that you do or don't have with your software vendor. We didn't get into that a lot, but that is something to be aware of. So to answer your question, no, I've not seen anyone get burned just because of that clause. It's been a talking point in lawsuits that I've been involved with, but it hasn't been the deciding factor or even the biggest factor necessarily, but it certainly has been an issue where you did agree to it, and you did agree that the vendor could change the terms, and they did change the terms, and now there's a dispute, but you already agreed to it. So we have seen that come up. We have seen some customers get burned by it, but that's usually one of many things that we see people getting burned by.
Yeah, absolutely. Another part of the conversation, to kind of switch gears, I guess, away from that, was that I really enjoyed was just the whole AI and ERP contracts. I feel like this is a newer, obviously, addition to all these contracts. And Marcus said that ERP vendors are fencing off customer data and even charging companies fees to access their own information, basically turning AI into a revenue stream at the customer's expense. Do you think that companies even realize they might be giving up control of their own data in these deals? And how should they be pushing back on this in contracts? I know you guys touched on this, just reiterating.
Yeah, I don't think most customers realize that they are, or if they do realize that they are ceding control, they don't understand what that really means. I was at a conference last year. I don't remember which conference it was, but someone in the SAP community, or I'm sorry, it wasn't a conference. It was a podcast, actually. It was a podcast interview that we did for our Journey to S4HANA podcast, which is it's a sister podcast of ours. And if you haven't listened to or watched that, if you're involved in SAP implementations, you should check out journey2s4hana.com is the website for that podcast. But one of the guests someone from SAP, it might've been Timo Elliott, if I remember correctly. But it was someone who worked for SAP. We were talking about how I think it was 30,000 SAP customers at that point had already agreed to use their data to train SAP's AI models. And I was actually pretty surprised that it was that high of a number, that 30,000 organizations had already done it. And for that many organizations to have agreed relatively quickly to allow SAP access to their data tells me that a lot of these organizations it's just impossible that they would have thought that through really well, what the long-term implications are in terms of what that means to their proprietary data, what it means to their competitive advantage, what it means to what SAP can or can't do with that data. I have to think that if that many organizations followed suit that quickly, that they weren't thinking that through really well. Not saying that's the wrong answer necessarily, but I just don't think they would have done it that quickly if they had thought it through. So anyway, so that's speculation on my part, but I think that'll be interesting to see how that plays out. But to answer your question, I don't think organizations realize a lot of the stuff that Marcus has talked about. In fact, I wouldn't have even realized this stuff if I wasn't talking to Marcus Harrison, interviewing him and working with him on a daily basis. I wouldn't have known that either. So I'm guessing a lot of organizations don't realize it either.
Yeah, absolutely. Another point about the AI that I found really interesting in contracts was basically you could be potentially handing over your competitive edge to your competitors in some of the contracts and the way they're structured. I found that point was really interesting and a point that probably a lot of companies had no idea about, especially if they're going into these contracts. So just another interesting point in general.
Yeah, that's a big one. I mean, I've always struggled with ERP software in general, that being the case. Even earlier in my career, when you could customize software and more companies were customizing ERP software, even back then it felt like there was such a tendency to want to use off the shelf software, which is understandable in some ways, but using off the shelf software means you're just designing your processes the way everyone else does. And in some parts of your business, that might be okay, but there's going to be some parts of your business where you don't want your competitors doing things the same way you do them, or vice versa. So now with cloud and now with AI, it's sort of like we continue to move this direction where the real center of power is moving to the vendors. The software vendors are the ones that are benefiting the most, not just in terms of the profit they make on selling software, but just the fact now that they're going to own these big, massive AI models. And you, as just one of, say, 30,000 customers that have ceded your data and ceded control of your data to a software vendor, now you've taken one of your biggest competitive critical assets as an organization. You just pass that on to a software vendor for them to get the real benefit and the real value out of it. So I don't know. I think it's a problem. I think it'll lead to a pretty significant backlash against ERP vendors longer term.
Yeah, absolutely. Like you said, I feel like we'll have to have Marcus on like at least once a quarter just to get updates on everything that's happening, especially as AI changes, like we say, like every single week. So
yeah, and every time he's on, it's like the next day I'll think of all these questions I should have asked him that I didn't think of until the next day. So, I just keep this running list of things I can ask him every time he's on.
Yeah, that would be good.
Yeah. Well, good. Well, that was a good interview. Love having him on the show, and we'll look forward to having him back. He'll be at our Digital Stratosphere conference coming up this summer as well. And if you're interested in that, you can go to stratosphere2025.com to learn more about that. But that's an event that we're hosting in person and a hybrid virtual event too. So you can go join it in person in Denver, or you can join it remotely and have access to the live content as well as recordings of the content as well. Go to stratosphere2025.com if you want to learn more about that. You can see Marcus there. You'll see Darian and I will be there. You'll see a lot of other speakers as well. So hope to see you all there. So we're going to play a clip here from my YouTube channel where I talk about why I think ERP software vendors are the new mafia. And more importantly, we want to talk about not only why I think that is and why some might say, it's a pretty strong choice of words, but I think it's worth maybe thinking about how software vendors, especially the bigger ones, how they're acting in many ways like a bunch of gangsters, thugs, mafia people, whatever you want to call it. And the real reason I want to share that is so you can be aware of it, but also to figure out how you're going to mitigate the risk of that. We're not going to change that in the industry. That's how they act. That's how they're going to continue to act in the short term, at the very least, until the model backfires. So what do we do to mitigate that risk in the meantime? That's what we want to talk about here in this video. So we'll roll you this clip of the video from our YouTube channel, and then we'll talk about it here in just a moment.
We're helping clients define their digital strategies and ultimately implement whatever technology or technologies they've selected. We find that there's a lot of gamesmanship that's played by software vendors, and software vendors are really the masters of extorting their customers and forcing customers to do things that they may or may not want to do, or that may or may not be best for their business. Now, of course, we're all out to make a profit motive, including software vendors, but there's a fine line between profit motive and profit motive at the expense of putting your business at risk. So what I want to do today is chat through and talk through some of the things that are signs of potential vendor extortion, as well as at the end of this video, I'm going to talk about some mitigation strategies you can put in place to ensure that you're in control of the project and not your software vendors. Before we dive too far into today's content, I want to share a little bit of information about Third Stage Consulting and who we are. Third Stage Consulting Group is an independent, technology agnostic provider of consulting services to help clients through their digital transformations. We help with digital strategy and software selection, as well as implementation planning. And during implementation, we provide services related to program management, organizational change, business process improvement, as well as enterprise architecture. These are just some of the services we provide. We have offices in North America as well as Europe and Asia Pacific. So if you'd like to learn more, I encourage you to check out our resource center, which includes a number of resources that will help you through your digital transformation, and you can access that for free using the QR code here or the links below. You can also reach out to me directly if you'd like to discuss your digital transformation and brainstorm ideas on how to improve where you're headed on your journey. Now let's jump back into today's content. One of the first and most relevant ways that software vendors are creating the sense of customer extortion in 2025 is in the way that they're forcing customers to upgrade their software. So in other words, you have customers that have implemented and spent a lot of money implementing big complex systems years or decades ago, and they're being told that they have to upgrade to a new system in order to continue getting maintenance and support. And the really strange thing about this, and the highly unethical thing about this, in my opinion, is the fact that customers are already paying for support and maintenance as it is, so it shouldn't matter whether or not they upgrade to the new system. Of course, no software vendor can support a system indefinitely, so there needs to be some sort of time box on how long they can provide support. But many of these systems haven't been around that long. It's just that most vendors now are moving to the cloud if they haven't already been in the cloud. And that's really the thing that the software vendors are trying to force, is to get more customers to migrate to their newer cloud solutions. Now, you could argue that some of these cloud solutions might be better for you as a customer, but in my opinion, it shouldn't be the software vendor forcing you or threatening you to move to the cloud solution. So I think that's the big difference between business value you might get out of a newer system versus the fact that you're being forced to do it. And so ultimately, what organizations need to do is upgrade on their own timeline, regardless of any sort of coercion that software vendors might provide. One thing that software vendors are also guilty of is convincing customers that they should go all in on their technology solution. And in particular here, I'm talking about the big ERP software vendors, the vendors that provide end-to-end software capabilities. They will generally try to get their customers to invest as much money as possible in their software, and they'll try to extend their footprint of their technology as broad as possible within the organization. Now, again, there's nothing wrong with the profit motive and capitalism and software vendors trying to sell more software, but there is, again, a fine line between selling more software and doing it at the expense of putting a business at risk. And that's oftentimes what happens, because most of these software vendors can't be everything to everyone within any given organization, yet they try to force the customer's hand. And what this all-in mentality does is it creates vendor lock. And vendor lock is a situation where you can't get out of the situation, or you can't get out of the contract without a severe disruption to your business. So if you think about however many employees you have, however many business processes and functions you have in your organization, if every one of them is using a certain software vendor's system and all the data is housed in that software vendor system, they sort of have you captive, and it's very hard to switch. So that's what vendor lock is, and that's the risk of going all in on one solution. And even though this is something that's very unhealthy for customers, vendors still push this concept very aggressively. Software vendors are also guilty of offering false promises to customers. Now, this isn't all necessarily nefarious behavior on the part of software vendors. They truly do believe some of the things they sell, but the problem is oftentimes they're selling a vision or a state of utopia that just isn't realistic for most organizations. So, for example, when you think about an implementation timeline or an implementation budget or the level of risk of implementing a solution, it's easy for a software vendor to say, it's easy to implement, it's not going to cost you that much money, and it's going to be low risk. But the reality is there's a difference between rolling out that software vendor's technology and actually transforming and changing your business and then adopting the technology. Those are two very different things. So what ends up happening is people end up with unrealistic expectations about what it's going to take to succeed with that software, and they end up set up for failure because they had these unrealistic expectations from the start, and these expectations were typically set during the sales cycle with the software vendor. And when I say software vendor, by the way, I'm not just talking about the software manufacturer. I'm also talking about the implementer, the technical implementer of that software as well. So when you're evaluating software vendor proposals, you have to take it all with a grain of salt, and you want to make sure you take the time to validate the assumptions they've used, and make sure you add a dose of skepticism to the assumptions that they're providing to you. And this will ensure that you're more likely to create a more realistic implementation timeline and budget for your project. Even though I've shared with you some bad news so far in this video, I have even worse news to share with you now. And this has nothing to do with the software vendors, it has to do with you, the customer. And the problem and the big challenge here is that customers are letting software vendors do this to them. Customers are believing what software vendors tell them. Customers are agreeing to terms that don't make sense. Customers are agreeing to assumptions that aren't realistic. And at the end of the day, it's almost like a buyer beware sort of situation. You have to do your homework. You have to validate. You have to question. You have to understand. And you have to have enough knowledge and foresight to really dig into what the software vendor is suggesting to you. And one way to look at it is if a software vendor offers you something that sounds too good to be true, it probably is. If they're telling you their software is easy to deploy, it's probably not. If they're telling you there's no real risk you need to worry about, there probably is. So you have to go in with the assumption and the mindset that there are risks. This is probably more complex than you realize and or what your software vendor realizes. And it's just going to take you more time, money, and risk than you imagine. And so if you go in with that assumption, you're a lot more likely to end up with a realistic plan, one that reflects reality, and one that has a healthy dose of skepticism to ensure that you're not setting yourself up for failure, but instead you're setting yourself up for success. So the biggest lesson I can leave you with here today is to ensure that you're not letting the software vendors engage in this sort of extortion or coercive behavior. It's really up to you to make sure it stops, and it's up to you to make sure that you do what's right for your business and that you aren't necessarily overly concerned about what the software vendor's motives are. You need to focus more on what your motives are and your priorities and make sure you work with a partner and a vendor that helps you do that. So it's safe to assume that if you're working with a software vendor, especially one of the bigger software vendors or one of the bigger system integrator consulting firms, you're probably going to experience some of these coercive types of behaviors if you haven't already. So the biggest way that you can overcome this is to educate yourself. Make sure you understand what you're getting yourself into, network with peers, understand what other companies have been through, and don't rely just on what the software vendor feeds you. If they give you a reference, that's great, but they're going to give you the best possible customer reference they can find. It's more important to go find references independently to see what the good, the bad, the ugly was of that software vendor or of the related implementation. The other thing you could do is hire an independent and trusted technology advisor like Third Stage Consulting, one that's not affiliated with a software vendor and one that can help you navigate some of these complexities and acts of extortion along the way. We can help manage that and help leverage our strength in the marketplace to help ensure you get the type of deal and the type of arrangement you're looking for.
So that was my take, I should say, on why I think ERP software vendors are the new mafia. What were some of your thoughts after hearing that video, Darian?
Yeah, I mean, I thought it was a great video overall. I think that obviously you talked about this, but one of the biggest frustrations companies face was when dealing with software vendors, the feeling of being forced into decisions they don't want to make. And I think that really is just not ideal, obviously, for a lot of companies, and vendors obviously are wanting that position. So I guess I have some follow-up questions for you from this video to kind of get further into it. One of them is you have mentioned that software vendors often use tactics to get customers to upgrade. Can you walk us through some of the most common ways vendors pressure companies into spending more?
Yeah. Well, first of all, what they do is they will either make it impossible for you to buy an older version of software, or they'll stop commissioning sales reps on older software. So just as an example, this was years ago, back when companies were still interested in JD Edwards, which is a product that Oracle acquired and still owns. There was a transition period where there still are a lot of customers using JD Edwards, but not many buying it still. These are legacy JD Edwards customers. But for a while back there was a time where we would have clients come to us and say, hey, we're a manufacturing shop. We're on an old version of JD Edwards, and we want to upgrade to a newer version of JD Edwards. And we'd go to the Oracle community and try and, work with whatever partner made sense. And, we learned quickly that not only is Oracle making it very difficult to buy newer versions of JD Edwards, they had actually stopped commissioning reps on selling any JD Edwards because they wanted everyone to move at the time to Oracle e-Business Suite. Now it's Oracle Fusion, but at the time it was Oracle e-Business Suite. And that one just stands out because at the time we had so many manufacturing clients that were still interested in JD Edwards, and it was like pulling teeth trying to say, hey, we've got a customer that wants to spend money on JD Edwards, but Oracle wanted them to go to e-Business Suite instead. And so they would make it really difficult, if not impossible, to get that software. So, it's been going on for a while. SAP is doing it now. If you want to go buy, the newest version of ECC, they're not going to let you. You're going to have to go to S4HANA, which is a complete re-implementation if you're already on ECC. So that's one way they do it, is they just sort of limit, they sort of cut off the ability to buy and the ability to commission. They stop commissioning sales reps on it, which that's going to create a lot of pressure in the industry to do something different, which is move to the newer version of software. And then the other bigger one that's more pronounced, I think, and the more obvious, painful one for customers is these arbitrary dates that these vendors have set to sunset their old products, that's nothing new. These software vendors have a right to sunset products over time. They've been doing it forever, and they can only support really old systems for a certain amount of time. But the problem is, you look at like SAP. Some of these customers they have, some of these big Fortune 500 companies never fully got through their ECC implementation in the first place, and now they're already being forced to upgrade to S4HANA because they're going to lose support on ECC. So that's the way they are doing it now. Is they're sort of setting arbitrary deadlines where we're going to cut off support on this date, so you better get moving on your upgrade to whatever product we want you to get to now. That's probably the biggest one that SAP and Microsoft, in my opinion, are the most guilty of this. So Oracle's doing it too, maybe not quite as aggressively, but still fairly aggressively. And a lot of the other vendors are starting to do it too. So that's the biggest one, is just cut off the support and maintenance, and hope that as many customers as possible move over to the new product.
Yeah, absolutely. And when this happens, how can companies push back against a vendor when they're maybe forcing this unnecessary upgrade?
Well, I think that first thing is just recognize you are the customer. You do whatever you want. You don't have to do what SAP wants or what your software vendor wants. So that's the first thing, is just have the confidence to know you are the customer and you're the one with the money. And just because SAP decides they're cutting off support doesn't mean you have to move. And the other thing too is not only recognize you're the customer, but recognize what your options are and what your leverage is. Your leverage is, you could go look at Oracle. If you're an SAP customer, go look at Oracle and Microsoft then. Or if you want to stay with SAP, tell them to pound sand. I'm not migrating from ECC just because you're telling me I have to. I'm going to stay on ECC for however long I want to, even if it means I don't get your support from it. And by the way, if I don't get your support on this software, then maybe I go find a third-party provider like a Spinnaker or Rimini Street or whoever. That's an option. Or, God forbid, I just say, I don't need anyone to provide support. I will support it myself and maintain it myself for as long as I need to. There is risk associated with that, of course, but you have to look at, is that risk any greater, or is it as material as the risk of spending money on a software perhaps you don't need, or going through a risky project, or putting your operations at risk when you don't need to. You have to assess and weigh all that cost benefit, not just, am I going to lose support? Because I think a lot of IT people panic and say, oh, well, I can't live without support from SAP, so I have to do something. And not enough people look at it from an objective business perspective to say, well, hold on. Yeah, there's a risk there, but perhaps implementing a new system is even riskier and costlier than the cost and risk of just maintaining, an old system or trying to maintain an old system. So that's the other thing, recognize what your options are, recognize you're the customer, know what your leverage is, look at your options, because you probably have more options than you think and that the vendors are telling you. So, and get that objective view. That's why we do so well in the marketplace. We at Third Stage Consulting is because we're independent and we're not affiliated with these software vendors. We just help clients understand what their options are, and we help them make the right decision that makes the most sense for them.
Yeah, absolutely. Well, what a great episode today. I feel like a lot of great topics were covered, and especially learned a lot from Marcus, of course.
Yeah, absolutely. Yeah, great stuff. And thank you for all the great content you provided today. Thank you to Marcus for the interview and for his time. And thank you to the audience for the great questions as well. Love hearing those questions here in the episode. And new episodes drop every Wednesday at transformationgroundcontrol.com. Be sure to subscribe, share it with your colleagues, anyone you think might enjoy the show. We appreciate you getting the word out to as many people as possible. We'll see you next week on the next episode of Transformation Ground Control. In the meantime, have a great week, and we will see you soon.